Sister Tebogo Butle, I see 5 members. We 5 or 6, so that if we correct, we can start.
Morning, Chairperson. Yes, we are only 5.
Okay, let's wait for a few seconds or minutes. Hopefully, a member will join so that we can start.
Chairperson, Dr. Burke just joined, so now we have 6 members on the platform.
Okay, thanks. Thanks very much. Let's start with our meeting. Let me officially open this meeting where, as the committee, we are going to engage the FSCA and stakeholders that we have invited. The meeting is officially open, and let me welcome all members of this committee. You are welcome, colleagues. Welcome, FSCA colleagues, National Treasury, if they are here. Welcome the stakeholders that we have invited to appear before this committee. Welcome the support team of SCOF and other organs in Parliament and the media. Roll call and apologies.
We don't have any say because Dr. Beck had sent a message that he won't be in the meeting, but he's since joined.
Okay. Let's move to item 3.
Chief,
Yes, Dr. Beck.
just a note that I have an unavoidable engagement at 10 o'clock, so if I'm not done by then I will ask indulgence for you.
Okay. Thanks, Dr. Beck. We have convened this meeting to deal with the issues that we received from members of the public who approached this committee. It was, I think, from the 6th Parliament. Be that as it may, we felt that it is time that we have to invite them, to listen to them, and then also give FSCA to brief us as to how they've dealt with their cases. We are not a structure of appeal. We are a Parliament. Parliament is accessible to the people of South Africa, and we are playing oversight role. Parliament has adopted what we call an oversight model, which oversight model stipulates that Parliament has got 3 key functions, which are representative function, legislative function, and oversight function. Playing oversight improves the transparency of government operations, and enhance public trust in government, which itself is a condition of effective policy delivery. So if members of the public have issues with government and they approach Parliament, we don't tell them that we are not a court or a structure of appeal. We listen to them and see how we deal with issues that affect them, because they voted for this Parliament. And what we are doing in terms of oversight and accountability is derived from Section 55, subsection 2 of the Constitution, that says that the National Assembly must provide for mechanisms to ensure that all executive organs of state, including the FSCA, in the national sphere of government, are accountable to it, maintain oversight of the exercise of national executive authority, including the implementation of legislation in any organ. It goes on like that, and even up to Section 59, and explain how National Assembly must facilitate public involvement in its business. In the fifth Parliament, we dealt with cases not of this nature, but whereby concerned companies or individuals approached us to raise issues, and we amicably dealt with those issues. It was cases that affected the Prudential Authority and the cases that affected the PIC. So it's not the first time that we deal with cases of this nature. And we know the boundaries of Parliament, organs of state that are entrusted with powers and functions to execute certain duties. So I felt I must give this background to explain why we're here. Moving forward, now that there is a petitions committee, because we didn't have a petitions committee in this Parliament, certain cases will be referred to that petitions committee for our colleagues to deal with them. And cases that we're going to listen to, or issues that are going to be dealt with today, also are transversal in the manner that they also affect the committee on trade, industry, and competition. So we'll see as to how do we work or collaborate with that committee to assist whatever issues members of the public have. Let me move to item 3 and invite the FSCA to give us a briefing on how they dealt with issues that we have referred to them. Thank you. FSCA, over to you.
Thank you very much, and good morning to you, Honourable Chairperson and Honourable members. Can I just double check that you can hear me very clearly?
Yes, we can hear you.
All right, thank you. So just to recap, Honourable Chairperson, my name is Fazana Badat. I am Deputy Commissioner at the FSCA. It is good to see honourable members once again after your in-person visit to the FSCA offices in Pretoria in October last year, which I hope was a very constructive visit. Honourable Chairperson, we were sorry that you were unable to join us in person for that visit. Thank you very much for this opportunity to engage with you once again. I have with me this morning other senior colleagues from the FSCA who are here to assist in providing you with more information on the 2 matters that have been referred to you by members of the public. Joining me this morning is Mr. Stephanus Rousseau, who is the FSCA's General Counsel, who will be providing you with a more detailed briefing on the FSCA's history relating to the complaint with Mr. Ryan Issakoff. I also have with me Mr. Mohompi Rapasha, who heads up the FSCA's frontline supervision department that oversees the conduct of insurance companies. He will be providing you with a detailed briefing on the FSCA's involvement in what is essentially a dispute between Hollard Insurance and Blue Ocean. Just to double check with you, Chair, are you comfortable for us to present to you on both the matters together and then we can open up for a discussion, or would you prefer us to take each matter in turn?
Whatever you think is convenient for you, please proceed. We don't have problem.
Okay, no. All right, thank you very much. Thank you very much. So we will deal with all of the matters together and then we can have a discussion. Before I hand over to Mr. Rousseau and Mr. Rapasha, I would just like to briefly share with you two important contextual points just relating to the approach and the mandate of the FSCA, which are directly relevant to the matters raised before you today. The first relates to the FSCA's mandate and approach to dealing with any complaints that are lodged by individuals against financial institutions. And the second relates to our mandate and approach when it comes to transformation. I do apologize to honorable members if I'm repeating information that's already well known to you, as I know we did provide you with some of this during your visit to the FSCA last year. However, I think similar to the honorable chairperson, where he kind of set a bit of a context for why we're here today from the committee's perspective, I think it's useful to just repeat some of this information very briefly to provide you background and context relating to the specific matters before you today. And hopefully this will just help with the deeper understanding of the approach that was taken in these matters when Mr. Rousseau and Mr. Rapasha present after I'm done. I am now going to share, we've got a presentation for you. I am going to share the presentation. If you can please let me know as soon as you are able to see the presentation. Okay. Can someone confirm for me that you are actually now seeing the presentation from your side?
Yes, we can see it.
All right, thank you very much. So as I mentioned, I will very, very quickly talk to you around generally our role as the FSCA when it comes to complaints, and secondly, our approach when it comes to transformation, and then Mr. Rousseau and Mr. Rapasha will take over. I do see that my connection is a little bit slow, so I'm going to switch off my camera just so that it can be a bit more stable while I'm speaking. So just in terms of complaints, I think, and again, the reason that I'm going to share this with you is it will become a lot more relevant when Mr. Rousseau takes you through the various forums that were approached by Mr. Issakoff in terms of his complaint, as well as just indicating to you the seriousness with which the FSCA actually took his complaint and the efforts that were taken to attempt some sort of resolution, even though the outcome was not satisfactory to him. So when it comes to complaints, there are obviously various role players that play different roles within the financial sector. The first avenue always when a financial customer or any member of the public has a complaint against a financial institution is obviously to go to that financial institution itself and to attempt to resolve the complaint. From the FSCA's perspective, our expectation is that that financial institution has an adequate and effective framework to manage those complaints in a fair way. If a financial customer continues to be aggrieved by the decision of the financial institution, the appropriate mechanism, again established by law, is the ombud schemes, and we've got a number of ombud schemes. We've obviously got the National Financial Ombud, which is an amalgamation of the former banking, credit, and insurance ombuds. We've also got the statutory ombuds, the phase ombuds, and the pension funds adjudicator. It is their primary and sole role to resolve individual complaints and to secure redress for financial customers in their disputes with financial institutions. Now, if a financial customer is unhappy with the decision of the ombud, their mechanism for further redress is either to go to the Financial Services Tribunal or the courts. So the Financial Services Tribunal would look into and reconsider the merits of the ombud's ruling. Of course, if it is found that the complaint itself falls outside of the mandate of the ombud, alternatively, which is also, I think, relevant here, if the complaint relates to a dispute between two financial institutions, the appropriate mechanism would be to go to the court of law. Now, what does all of this mean for the FSCA's role? So the FSCA, in terms of its mandate, does not and should not adjudicate individual cases. That does not mean that we don't look at complaints. On the contrary, we do deal with thousands of complaints. Our primary responsibility when it comes to complaints, we've got a number of responsibilities when it comes to complaints, but most importantly, it's to assess the complaints in order to determine whether there is some sort of regulatory contravention, whether the complaint speaks to some sort of broader misconduct or problem within the financial sector where we need to intervene. Similar to the ombud, decisions that are taken by the FSCA are subject to appeal or review by the Financial Services Tribunal and or the courts. Again, this will become relevant because I think in Mr. Iskov's case as well, he did take the determination of the FSCA to the tribunal. And again, Mr. Rousseau will share with you what the outcome of that was. This, and I'm not going to go into this in detail, but it basically repeats what I've said, which is that the role of the FSCA is to regulate financial institutions on a systemic level. When it comes to complaints, we do assess complaints that are brought to us, but we look for patterns of behavior. We look to see whether there are specific regulatory breaches and whether there's contraventions where we need to take enforcement action. There are various types of complaints that the FSCA receives. We receive complaints about financial institutions. We receive complaints about people that are conducting financial services business without licensing. And of course, we receive complaints against the FSCA itself or FSCA officials, again, such as the case with the two matters today. It's also important to note that even though complaints is not our core function, we do receive thousands, huge volumes of complaints every year, which we work through utilizing a risk-based approach. Just as an example, the committee would know we published our integrated report last year, and we'd indicated that just last year alone, we'd received over 10,000 complaints and queries. And out of those complaints and queries, we'd managed to resolve and close about 87. So in the report, you will note that of those 10,388 cases, we managed to resolve 9,037. Just moving on very quickly, and again, just hopefully some of what I'm saying now will help provide a bit more clarity when it comes to the approach that we've taken with the matters. The second issue relates specifically to the matter in respect of Blue Ocean and Hollard. Again, we did spend some time with the committee previously talking through our approach to transformation and obviously some of our current limitations and future plans when it comes to our ability to take stronger action for transformation. So I'm going to go through this very quickly. I think essentially what I just wanted to remind the committee that under the current framework in which the FSCA operates, we have extremely limited powers when it comes to requiring specific actions by financial institutions when it comes to transformation or reporting on transformation. This does not mean that we don't currently invest a lot of time. The work that we're doing right now is engaging with financial institutions to understand from their perspective the efforts that they are taking to accelerate transformation in the sector, because similar to the committee, I think we also are quite frustrated with the lack or the slow pace of transformation of the financial sector. We've also built relationships with the Financial Sector Transformation Council and the BBBEE Commission. We are also working on the type of data that we will need in the future to enable us to have a better sense of the state of transformation in the sector. Now, the second part of our approach to transformation is what will come into being, hopefully, once the Conduct of Financial Institutions Bill is enacted. And again, I'm quite optimistic that the committee will be seeing that bill pretty soon within this year, because there are a lot of regulatory interventions introduced by the COFI bill that will strengthen our powers, not just when it comes to transformation, but a number of other issues to help address serious risks and issues that we're finding in the financial sector. Now, under the COFI bill in future, the FSCA will have much stronger powers to set specific requirements when it comes to transformation, but also importantly to take very strong and concrete action against financial institutions if we find deficiencies in terms of their initiatives and their commitments when it comes to transformation. Now, against this backdrop, it's also important to understand whether there were any regulatory considerations in respect of transformation that were applicable to the Blue Ocean Hollard matter. I'm not going to go through this in detail because, again, Mr. Rapasha will go into the details of the relationship and the engagements that the FSCA had. But at this point, what's important to know is that the origin of the Blue Ocean and Hollard matter was not rooted in transformation. In other words, it was not rooted in any requirement in the law for such an arrangement or relationship to be concluded aimed at furthering transformation, because there are no regulatory requirements that empower us to compel or force this type of relationship. Instead, Hollard and Blue Ocean are both licensed financial institutions under separate financial sector laws. We do have a regulatory framework which the FSCA uses to supervise the relationship between insurers and intermediaries, Hollard being the insurer here and Blue Ocean being the intermediary. The genesis of this dispute was a contractual commercial agreement between Hollard and Blue Ocean that was governed under, from an FSCA perspective, regulations in terms of the Short-Term Insurance Act. These regulations deal primarily with oversight and remuneration arrangements. So in other words, limits around the types and level of payments that an insurer can provide to an intermediary, and also the level of oversight that the insurer needs to have if an intermediary is acting in its behalf, on its behalf. These regulations do not deal with transformation issues and do not provide any guidance. The reason that transformation became a very significant consideration for the FSCA in this case is the parties approached us asking very strongly for an exemption from the regulations. In other words, the parties requested that Hollard be allowed to pay Blue Ocean additional remuneration to what is allowed under the law. And the motivation that was provided for that was that this additional financial support would be required in order to support and assist Blue Ocean to realize its future aspirations to grow from a small intermediary into an underwriting manager and eventually into a fully fledged insurer. So the motivation that was provided was the FSCA must please provide an exemption from these regulations in order to help support and accelerate financial sector transformation. This was the first case of its kind that the FSCA dealt with, where we received an application for an exemption from existing regulation that was motivated on the grounds of transformation. And for this reason, we did consider it and took this very seriously because of the compelling public interest in terms of finding creative ways to accelerate financial sector transformation. I'm going to stop here. This is just very briefly some context, and hopefully this will just help shape and support some of the details around the approach that was taken by the FSCA in both these matters. I'm now going to hand over to Mr. Rousseau, our General Counsel, who will take us through the way and the reasons for the way in which the FSCA dealt with the ISCOF matter. Fanny, Stephanus, over to you. If you could just help me in terms of when you are ready to move from one slide to the next, that would be appreciated. Thank you very much. Fanny, over to you. Fanny, I just want to double check if we've got you on the line. I don't know if you're having problems with your sound.
It's on the line. His microphone is open.
Yeah, I wonder if he needs to change some of his settings. So apologies, we don't generally use Zoom on our side, so he might just be having an issue with his settings. I'll just give him a few seconds. Fanny, I don't know, are you able to put a message into the chat as to whether you are having an issue? If so, we might just move over to Mr. Rapasha and come back to you a bit later. Okay, I think I will probably hand over to Mr. Rapasha and just try and find out if Fanny is having any challenges, and we'll come back to that. Mohompi, can I just check if you're on the line and if you're good to go?
Yes, thanks, DC. I am on the line. I don't know if you can hear me.
Very well. We can hear you and see you very clearly. All right. So,
Thank you.
I will let you. I just want to ask other colleagues, other FSCA colleagues on the line, if they can please just in the meantime liaise with Stephanus in the background to assist him to just get his settings right while I'm navigating the slides for Mohompi. But Mohompi, I'll hand over to you.
Thank you, DC. I think if you can just move on to the next slide. Thank you very much. Good morning, Honorable Chair and committee members. I'm going to talk to you about the Blue Ocean and Hollard matter. As the DC indicated, this is a matter that we dealt with from a transformation perspective as the FSCA being the conduct regulator. We started dealing with this matter in 2021 when we were approached by both Hollard and Blue Ocean regarding the business arrangement that they were intending to conclude at that time. Based on the discussion that we had with them, we were informed that in terms of the arrangement, Blue Ocean was going to sell certain commercial insurance policies on behalf of Hollard, and they were going to be remunerated by way of commission as provided for in the insurance regulations. We were also informed that this was not the normal intermediary insurer relationship where it was just based purely on the sale of insurance policies. But over and above that, the intention was to help Blue Ocean to progress from being an intermediary to become an underwriting manager and eventually a fully fledged insurer. There were, however, various financial and operational limitations, and those had to be overcome in order to really assist Blue Ocean from moving from a purely distributor of insurance products to becoming a UMA or underwriting manager in full, and eventually an insurer, as I have indicated. What is important to point here to the committee members is that the insurance legislation imposes certain caps in terms of remuneration that can be paid to intermediaries. And the purpose of these caps is to really protect financial customers against the risk of inappropriate advice and mis-selling, which generally refers to the inappropriate of selling of insurance policies. So exemptions of this nature are not granted lightly by the FSCA. They are really subject to scrutiny and to compelling public interest motivation, as the DC has already indicated. Over and above that, they are also subject to a very strict internal governance process within the FSCA. And also this process is also linking to the concurrence process that we have with our sister regulator being the Prudential Authority. In terms of this arrangement, then we were also informed that the exemption was really necessary to allow additional remuneration to be paid to Blue Ocean so that it can continue in its journey to eventually becoming a fully fledged insurer. So there was really a need to allow Hollard to pay over and above the caps that are set out in the legislation. DC, if we can move to the next slide. Yes. So now coming to the exemption itself, we really considered the exemption for some time within the FSCA. And after much consideration and strong undertakings from both entities, being Hollard and Blue Ocean, we granted this 3-year exemption on the 7th of April 2022. The exemption was subject to certain conditions. The most important one to highlight was the progression plan that had to be submitted by Hollard, setting out the clear milestones aimed at supporting Blue Ocean through its journey of becoming a fully fledged insurer, and in the process to develop insurance expertise during the duration of the exemption. This progression plan was also required, and this is what our documents clearly indicated, was to be signed off by Hollard's board of directors. And the reason why we imposed this requirement was to ensure that, because this is a very important matter, it was not really dealt at junior level, but it was really dealt with at the highest structure within Hollard. Hence this requirement for the transformation plan to be signed off at board level. Now, between 2022 and August 2023, August 2023 being the time when the arrangement was terminated, as I'll come to that in a second, Hollard approached us as the FSCA, and they requested several extensions to submit the progression plan that was required as part of the exemptions. I must, however, point out at this time that at that time, Holland had already indicated there were a few challenges with the business arrangement with them and Blue Ocean. But there was no indication that those challenges were insurmountable and could lead to a breakdown of the business relationship. In fact, what I can also highlight is that shortly before the arrangement was terminated, we were made aware of arrangements, the plan of entering into a binder arrangement between the two entities. So there was no indication at that time that anything was really wrong. So we believed that the few general challenges that were highlighted were really going to be overcome by both parties to continue with this business arrangement that was very important for transformation purposes. DC, if we can move to the next slide. Now, coming to the termination of the business arrangement. So in August 2023, then we were made aware of the termination of this business arrangement by Holland. And at the initial stage, we were not entirely clear about the reasons that were provided to us for the termination of this business arrangement. That resulted in us then engaging with both entities just to get a better understanding of what led to the breakdown of this relationship. But also as part of that process was also to establish whether either party had contravened the conditions of the exemption or any other financial sector law. Our engagement with the entities revealed very conflicting views that we get from both Holland and Blue Ocean. Each of them believed that they had performed as initially intended and as conveyed to the FSCA when they were applying for this exemption. We were also in that process, Chair and honorable committee members, made aware of the commercial settlement dispute that Blue Ocean had instituted against Holland as a result of the termination of this business arrangement. I need to emphasize that also at that time, Chair, the FSCA was pressured by Blue Ocean to actually release its report on the findings of the investigation, the assessment that we were conducting. We made it very clear to Blue Ocean that we had no role to play in the settlement of the said dispute. Our role as a conduct regulator was really limited to checking whether there was compliance with the exemptions conditions that we had imposed, and also to really check the veracity of the representations that were made to us by both Blue Ocean and Holland. We considered this matter to really determine on the appropriate way forward. So we did not want to enter into the commercial dispute, and then the parties were clearly advised that that was not what the FSCA was going to consider. So in terms of the assessment that we conducted, Chair, this was very detailed. This was very thorough. As I've indicated, the purpose of this assessment was to really determine whether the conditions of the exemption had been complied with and whether there has been any contravention of a financial sector law. But most importantly, in line with our mandate, which part of it relates to promotion of fair outcomes by financial institutions to financial customers, we also had to check whether there was any material prejudice to customers as a result of arising from this breakdown of the relationship between Holland and Blue Ocean. We did not find any contravention of a financial sector law by either party. However, we had some concerns about the parties having estimated their capacity to really pull off this kind of an arrangement. And then we indicated our concerns to the parties, because in our view, we believe that both parties overestimated their capacity and ability to actually have these arrangements being a success. The shortcomings that we have included, that we have identified, included Hollard's feasibility and sustainability or assessments, that there was no proper assessment that was really done at the outset in terms of this being a viable arrangement going forward, particularly for the period that it was intended, being the 5-year period. We also felt that Hollard underestimated the level of financial and operational and technical support that was going to be provided to Blue Ocean. But at the same time, we also found that Blue Ocean had overstated its ability and capacity to fulfill its side of this arrangement, particularly if one takes into account that the intention was later on to progress from being an intermediary to an underwriting manager and eventually to a fully fledged insurer. Things like senior underwriting staff were really lacking on the Blue Ocean side. So all of this, Chair, led to the withdrawal of the exemption. So the breakdown of the relationship between the two entities, and we also considered the discretion that we had when we issued the exemption. We made it very clear that the exemption could at any time be withdrawn by the FSCA at its discretion. And we also made it clear when we issued the exemption, Chair, that failure by either party to comply with any of the exemption conditions will result in the withdrawal of the exemption. So we found no evidence of material prejudice to customers or any other regulatory breaches. And as a result, we could not lay a basis for any enforcement action that could be taken against either Hollard or Blue Ocean. What I want to emphasize here, Chair, is really going forward. We have obviously learned lessons from this arrangement between Blue Ocean and Hollard. And as the DC indicated, this was the first of its kind that was considered by the FSCA from a transformation purposes, and also under the regulations that, as the DC correctly pointed out, they do not really deal with transformation per se. So what we are going to do going forward in respect of similar applications in the future is to really scrutinize those applications and to ensure that what happened here does not reoccur, Chair. So that is really the journey that the FSCA took throughout the Blue Ocean matter, right before the exemption was entered into. When the exemption was entered into, our engagements with the entities throughout the exemption period up until the withdrawal of the exemption. I'm going to pause there, Chair, and then we will take questions on the Blue Ocean and Hollard matter. I'm going to hand over back to you, DC, for the other matter for Mr. Rousseau to take the committee through. Thank you.
Thank you very much, Mahompi. Appreciate your briefing, and we do look forward to more questions from the committee. I understand that our IT team has tried to assist Mr. Rousseau. So, Fani, can I just double check that you are now able to speak?
Chair, honorable members, can you hear me then? Yes.
Yes, we can hear you and we can see you very, very, very clearly. All right, so I will hand over to you to take us through the Ryan Isakov matter, similar to with Mahompi. If you can please just cue me as you are ready to move from one slide to the next. Thank you very much.
Thank you, I'll do so. Good morning, Honourable Chair and members. I think we can start with the next slide, concerning the Isakov complaint, which was considered by the FSCA. And it's important to provide some background as to this matter, which started prior to the FSCA being approached with a complaint that Mr. Isakov lodged with the Ombudsman for Banking Services in 2018. That complaint included, the critical aspect of it was an allegation of fraud and theft of an investment amount of about 106,000 belonging to Mrs. Blumi Isakov, which I think was the complainant's mother. And that was initially held in a market account with Sambo Bank, and which subsequently to the curatorship of Sambo Bank was in an account of FNB, who took over that business. So in July 2018, the Ombudsman concluded on that complaint that there was no reasonable prospect of that office making a recommendation in the complainant's favor. Of course, then in plain words, that there wasn't evidence to sustain a finding of theft of that investment amount. The Ombud closed its file, and then Mr. Isakov lodged the same complaint with the same issues with the FSCA in June of 2019. So the FSCA, as the second peak in the twin peak model of regulation, came into existence on the 1st of April 2018. Prior to that, conduct matters were overseen by the Financial Services Board, as the committee will very well know. But the conduct of banks was not included in the mandate of the FSB since its inception from 1990. Only upon the FSCA coming into existence were banking issues included in the mandate of the FSCA. So nevertheless, that these issues and the facts relating to the complaint go back many years. In the case of the account at Sambo Bank of Mrs. Blumi Isakov, going back to 2001, 2002, and I think ultimately with her passing in 2004, the FSCA looked into those matters. So the next slide, please. And that investigation was conducted by the team dealing with the bank and payment provider specifically, and they communicated the outcome of their findings in October 2019 to Mr. Isakov. They concluded that there was no evidence to sustain a finding of fraud against FNB concerning this amount, which was the balance of those funds. So initially it was 106,000 in a money market account, and from which there were deductions, there were debits against that amount, and then ultimately a transfer of the balance of approximately 70,000 Rand from FNB to ABSA during 2002. The communication of the outcome confirmed that the money had left FNB, and ABSA confirmed receipt of the monies in 2002. So the FSCA's letter concluded by saying that there's already been a finding of this by the Ombudsman in that framework that Fazana spoke about of complaints resolution and the FSCA, but that the complainant didn't seem to accept that. So at that time, in 2019, the FSCA already advised if there is a dispute about this, you must seek legal recourse through the courts of law. In November 2019, the complainant utilized another mechanism, which was to lodge an application for reconsideration with the Financial Services Tribunal, which is a body independent from the FSCA for reconsideration of a decision. The tribunal summarily dismissed the application in January 2020 and found that the application was vexatious. So next slide, please. Yep. So in December 2020, Mr. Isakov then approached the then acting commissioner of the FSCA, Mr. Olano Makubelo, and expressed dissatisfaction with the investigation, and also in that process leveled accusations of bribery and corruption and of a cover-up by FSCA, FNB, and ABSA. So, because this is now leveled against the FSCA officials who were involved in that investigation, the acting commissioner, Mr. Makubela, proposed a review of all the evidence, because that would bear out factually whether the findings were correct or not. That review process, including further engagement with the banks and with Mr. Isaacov, was concluded by September 2021, and it was completed under the oversight of the newly appointed commissioner, Mr. Unati Kamlana. The committee members will be aware that Mr. Kamlana was appointed with effect from 1st of June 2021. So this being a matter that Mr. Makubela was no longer the acting commissioner, resorted under the oversight of the commissioner, Mr. Kamlana. So all of the available evidence, the documentation were reviewed, and it was done by personnel who were not involved in the initial investigation of 2019 in the banks and payment providers, because they were then accused of a cover-up by the complainant, including myself as general counsel for the FSCA and another senior official, Ms. Sarina Kamrudian. Next slide, please. So following those further engagements and the follow-up with ABSA Bank in particular, because of an allegation that the statement showing the receipt of money, the balance of the money into an ABSA Bank account, was a fabrication. It was a typed up document. That was the allegation that was made. There was engagement and explanations were received for that. So what the FSCA also did is to engage with independent external counsel, experience in banking matters, to consider that assessment of the review. And counsel agreed with the findings, the FSCA's review findings, that there was no evidence indicating any theft or fraud on the part of the banks. So the committee will remember that we initially received a complaint comprising of 6 issues, this being the critical one, but which seems to be the matter for dissatisfaction and why this is before Parliament today. But the other 5 issues were also again revisited. They included matters such as unauthorized debit orders, an account closure for Mr. Julian Isaacov, I think the complainant, Telkom debit orders issues, an account closure, and banking fees, allegedly in excess of an amount of 60 Rand a month. And though those matters, some of them, such as the illegal debit orders, also go back to a period of between 2010 and 2014, well preceding the mandate of the FSCA. But nevertheless, all of those were revisited again and cleared up, and there was no evidence or indication to disturb the initial findings or outcomes on those other 5 issues as well. And so the commissioner wrote a lengthy letter, detailed, on the 7th of September 2021 to Mr. Isaacov, confirming that the matter is now closed. And in that letter, the commissioner expressed his dissatisfaction. He took exception to the leveling of unfounded accusations of corruption and cover-up against FSCA officials, simply because what would appear to have been dissatisfaction with the manner in which it was investigated or the outcome, not to the liking of the complainant. So Mr. Kamlana confirmed in that letter that he was satisfied that the matters had been thoroughly investigated and considered. And what he also did was to copy that letter to the National Treasury in view of threats by Mr. Isaacov to take the matter to the President's office, and because he had previously engaged with National Treasury. So about allegations of covers up. So the FSCA copied its response on the second review of the matter to National Treasury because it entailed a comprehensive review and exposition of the findings and the analysis of the documentation. So next slide, please. Thanks. So what has happened subsequently, Chair, is that Mr. Isaacov approached National Treasury again. So the letter from the Commissioner, September 2021, almost 3 years later in 2024, National Treasury is approached again by Mr. Isakov, and the FSCA provided the relevant details and explanations again to National Treasury. And I think it was after that that the matter was escalated to this Honourable Committee. As far as the documents and the analysis of what the FSCA did, its position remains unchanged. The complaint, the issues have been reviewed twice, the initial investigation plus this review of the evidence, and it has been checked with outside independent external counsel who validated those findings, couldn't disturb that from the FSCA side. And it was also dismissed by both the Ombud and the Financial Services Tribunal without merit, and the tribunal's case labeling it as vexatious. So, Chair, in as much as there may be a dispute of fact here, the FSCA's position is that the appropriate mechanism is for the complainant to seek redress through the courts of law. That is what Section 34 in the Constitution guarantees, where any dispute may be resolved by the application of the law. So if Mr. Isakov is in possession of relevant information or evidence that there has been fraud or theft perpetrated by the banks, or that the FSCA in some or other manner misdirected itself, that is the mechanism to resolve it, and it's open to the complainant to do that. Thank you, Chair, honourable members.
Thank you very much, Fani. I think just to add to what Fani's said, two additional points. What we're also aware of is when the Financial Services Tribunal dismissed Mr. Isakov's matter, our understanding is that he was also dissatisfied and also laid a complaint against the then Deputy Chair of the Financial Services Tribunal, Judge Harmsa, for misconduct with the Judicial Service Commission. We're also aware that he has more recently also taken up the matter again with the Ombud, and again has taken exception to the way in which the Ombud structures have dealt with the matter. So, Honourable Chair, Honourable Members, thank you very much for your indulgence. I do hope this has given you more detail and context to how we've dealt with the matters, and we are now very happy to take your guidance in terms of engaging further. Thank you very much. Honourable Chair, I will hand back to you. I'm not sure if you're still on mute.
Thanks very much, Fazana, and your colleagues. I think we're done. Blue Oceans, Hollard, Ryan, Isakov. Then so we're going to request the three stakeholders to make comments. Then after that, I will request Advocate Jenkins to guide the committee. Blue Oceans, are you there?
Yes, Chairperson, you are here.
No, okay. Over to you.
Good morning, honorable members. My name is Winston Skosana. I'm the MD of Blue Ocean. We thank the opportunity provided to us. We lodged this complaint in February last year, and we are grateful that we are sitting here today to get input and clarification from us. And I thank the FSCA for their presentation and their input on this matter. We just want to bring the following to the honorable members and to the FSCA itself. I have noted that our complaint to bring this matter here to the committee, it's not to seek commercial settlement on the matter. We are pursuing this matter legally. There's litigation ongoing. When we met with the Deputy Commissioner, Fazana Badat, at the FSCA, once the termination was instituted by Holland, we were asked what is it that we want as a final result for this matter of lodging the complaint. We said that we want the FSCA to investigate the matter to find out whether Holland had complied with all the conditions of the dispensation. And secondly, we said we also want a settlement on our matter at the financial level. And the Deputy Commissioner did advise us that they can't play referee and play at the same time. They can't tell us or inform Holland and Blue Ocean to settle. That matter must go to court. And I'm happy to say that we have instituted litigation. Our request to come to this committee is to flag 3 things with the committee. Firstly, I hear that the Deputy Commissioner says that we pressurize them to issue a report in our favor. We never pressurize them for a favorable report for us. We pressurize them to issue a report timeously. Honorable members, if I can make a comment, we lodged a complaint with the FSCA in August 2023. The report that the FSCA produced was in September 2024. That's 13 months after we've lodged a complaint. In our view, that is not responding timelessly on the circumstances, on the issues. And that had an impact on us, of course, with our ongoing litigation matters, because we wanted to provide the process of our legal process with the report from the FSCA. Whether it's favorable or unfavorable, it's not an issue. The issue is to provide a report to our lawyers on the matter. And we only managed to get the report in September 2024 when we lodged a further complaint with the DG of National Treasury, Dr. Duncan Peterse. It's only then that we got a report on the matter. So to our view, 13 months, it's not a fair amount of time. It's unfair amount of time to investigate on this matter. Secondly, the dispensation had 3 conditions to it. The first one was progression reports to be provided regularly to the FSCA by Holland, which is the licensed entity. The board approved 3-year plan. The dispensation was for 3 years, and it was expected of Holland to provide a 3-year plan to the FSCA on incubating us as part of accelerating transformation. And thirdly, the remuneration model. Under normal circumstances, the intermediary commission provided for is 3.5% of the gross commission. The regulator gave dispensation that we must not get 3.5%, but we must get up to 10.5% commission of the gross premium. And in our view, and we have evidence to that, we've provided the regulator, FSCA, with information to show that, 1, Holland never adhere to the condition of the remuneration model, meaning that Holland wanted us to charge an additional top-up of the gross commission for our remuneration model. And this matter, by the way, we have also referred it to the DTIC committee in Parliament to do a further investigation on this matter, and we'll provide them with all evidence around competition issues and treating customers fairly. The FSCA itself on this matter of remuneration, in their report, and I can point you, Fazana and Makumpi, I'm not sure that this report was shared with honorable members, but if you go to page 5.17 of your report, Fazana, Deputy Commissioner, you say there, the last sentence, it is also not clear how the amount of 9,000 was calculated. This was just an example of the remuneration model that Holland expected us to top up, to charge clients more than what is normal for a risk that is presented to them. Holland, in our board pack that was submitted to FSCA as part of reviewing this arrangement that we have to show that Holland breached two things: the remuneration model that was provided, but also they breached the treating customers fairly, because this matter was raised with both Hollard, and we showed the regulator that Hollard was wanted us to have a top-up charge of the commission, not into the gross premium. The arrangement was that we will charge our remuneration from the gross premium, not as a top-up. And the board meeting of the 6th of December 2022, where Hollard had a representation in our board in the form of Nash Oma. Those minutes are there, and we've shared them with the regulator, and we can share them with the committee if needed or if it's required. With regards to the issue that we oversold our capabilities on this matter, we again dispute that, honorable members. Hollard did a due diligence on us twice. And that is why Hollard wanted to expedite the issue of making Blue Ocean a UMA, to move from an intermediary to a UMA in 6 months. It's because Hollard had a strong sense that we are now ready to become a UMA. But again, something along the line changed. We don't know what is that. That will be ventilated in a court of law, as we say that from a litigation point of view, this matter is going ahead. But all we wanted to bring to the committee today is that Hollard breached all the exemption requirements. And in our view, if someone has breached the exemption requirements, there's a legal basis and there's a legal duty, in our view, that Hollard should be penalized and fined. There must be enforceability for that, because the TCF, treating customers fairly provision, was breached by asking us to charge more for our clients outside of the remuneration model that was agreed, that it must be up to 10.5% of the gross premium. Hollard was not doing that. Hollard wanted us to charge clients over and above the commission of the gross commission, the gross premium that was charged. And we raised this with Hollard on various platforms up until in the December board meeting, where Hollard was represented, and those board minutes were shared with the FSCA. And that's when Hollard said to us, look, let's move away from this model and go to a UMA. Hollard would never say to us we should go to a UMA model if they were not convinced that we are ready and we are capable of delivering on the matter. And by the way, honorable members, Blue Ocean had 4 staff members. All these 4 staff members have got more than 60 years experience in the insurance services sector. We are still of the view that the report that the FSCA did from a regulatory supervision point of view, in our view, it's light touch. All the FSCA said at the end of the day is that this report that they produce must be shared with the board of Hollard. Remember that Hollard, we have never seen a board resolution from Hollard that gave the 3-year plan that was supposed to be part of this condition to the FSCA. So we're not even sure whether the CEO of Hollard has shared this report with his board as things stand right now. For us, in terms of lessons learned, we hear that from the FSCA, lessons learned is that transformation must be given another angle, must be given another opportunity. For us, lessons learned is that if there's no commitment at the top of a big institution like Hollard, transformation will never happen. The other point that we are bringing to your point for consideration as lessons learned, the team that did the exemption investigation on our matter with Hollard is the same team that did the investigation when the relationship collapsed. So in our view, that team should have been a separate team. The FSCA should have established a separate team to do an investigation once this dispute occurred. The other point that we want to bring to the committee as part of lessons learned is that the team that did the investigation on Hollard, on this matter, on dispensation, and once the relationship collapsed, is the very same team that is also supervising Hollard. And there's no rotation of teams insofar as we are concerned that supervises insurance or entities. So we think that just like the audit firms have come up with a plan that every 5 years the audit partner must be changed, we think that as part of our case study, the FSCA should consider changing their teams that are looking at insurance companies so that there shouldn't be embedded comfort between the team that supervises these institutions and the team that stays there forever in these institutions and platforms. But as we have mentioned that we have also engaged the DTIC on this matter. We've provided them with all the information so that they are looking at this matter from a different angle as opposed to the one that we have raised with the Finance Committee. From the DTIC, we want the BEE Commission to be involved and we want the Competitions Commission to be involved because Blue Ocean customers were unfairly treated in this matter with the way in which the remuneration model was done. The remuneration model was not implemented in the manner that the FSCA had intended. At that board meeting of the 6th of December 2022, we said to Hollard, let's go back to the FSCA and find out that is this how they intended the remuneration model to be implemented. Hollard itself, its legal guy was there, Danny Offe and Nash Omar, the CEO of Hollard Insurer. They said to us, let's not go there. We agree that we've applied the dispensation conditions incorrectly. And that is in the board minutes. The board minutes that were shared with the FSCA to this effect. And to us, that cannot be discounted to say Hollard complied or adhered to the conditions of the dispensation. Hollard never applied its mind correctly, and Hollard never complied with the conditions of the dispensation with regards to those 3 points that we had mentioned. Insofar as we are concerned, we have not seen any of that, especially with regards to the board-approved 3-year plan that Mr. Vili Lategan was supposed to provide, and the progression plans that were never provided to the FSCA on a regular basis, and a feedback to that effect. And the issue of the application of the remuneration model, we want the FSCA, we request that the FSCA should dig deeper because in their report, they are themselves, the FSCA are saying they are not clear how this commission remuneration model was implemented. And you cannot, in our view, provide a finalized report if you are still unclear about how the remuneration model worked. When we gave them all the documentation to the effect that Hollard breached the treating customers fairly provisions. And our report, our response to the Deputy Commissioner dated the 12th of October 2023, we touched on all these issues and we gave documentary evidence to the Deputy Commissioner on the 12th of October 2023 to this effect that the remuneration model was applied incorrectly and it was breaching the treating customers fairly. We even stated on our response to the Deputy Commissioner on the 12th of October 2023. And if possible, we would request that the Deputy Commissioner should circulate that response of ours of the 12th of October 2023 to the committee members. We are not here to come and complain and ask the committee to look at settlement for us. No. We have taken a legal approach on this matter. We have appointed attorneys. Hollard is aware. They are represented by Clyde & Co. They are aware. We have dealt with all the exceptions reporting our legal issues. We are now going to the next level on this litigation matter. But to us, the 3 critical things is that Hollard never complied with those 3 conditions of dispensation. And we want to know why the FSCA is not applying penalties and or punitive measures to Hollard for not complying with dispensation conditions and for breaching the treating customers fairly condition, which is part of a policyholder protection rule. And we have shown in various platforms and in various evidence that we have provided to the FSCA on this matter. I just want to once more emphasize that we didn't pressure for a favorable report. We were concerned that it took 13 months for the FSCA to issue a finding on this matter. I'm not sure my board chairperson is also here on the call. I would ask him to make comments on issues that I might have missed in my response on this matter.
Thank you, Winston. Can everybody hear me? Hello? Can you hear me? Yes. Thank you, Mr. Chair and the committee. Thank you very much for this opportunity. My name is Winky. My surname is Makasi. I am not a technocrat on insurance. I am not. And I will not start to behave as if I'm one. I'm a businessman, and I invested at the request of Mr. Vili Lategan. I invested into Blue Ocean. I put my money into the business as an equity partner. That's what I did. I've watched the circus unfolded in my face, and I've watched a big corporate strangling a small operator. I could not believe that FSCA became part of this. At no stage, as far as I'm concerned, did Blue Ocean pressurize FSCA to give a positive report, because that would be unethical. And I think it is important for the DC to give us an apology that we never did that. It is basically wrong to quote things incorrectly. It is wrong. We did not. We didn't go behind scenes and ask for a positive report. 13 months later, we got a report. That was our complaint. Now, I'm a taxpayer. I pay for the services that I think I deserve. Now, if FSCA is going to stand here and say we're begging them to give a positive report, that is not true. I pay tax like any other company. I run my own company. I never ran Blue Ocean. Yes, I was the chairman of the company. Yes, I sat on the board with Vili Lategan. But all I say is, FSCA, what we expected was for the truth to be told. The question that I would like to be answered, probably Holland can answer it. One of the conditions to ensure the implementation of this project was the board of directors of Holland must be made aware. I assume, in my language, it says there needs to be a board resolution on the matter. The question is, was that done? Because my perception, when I listen to the conflict of Blue Ocean with the middle management of Holland, when I go to board meetings, I realize that it doesn't sound like Holland board knew about this. Now, I'm not judging Vili Lategan, I'm not judging Danny Joffe. I am asking the question, is there evidence, FSCA, that there was a board resolution on this matter that included Blue Ocean and Holland? And if there is, I would like that board resolution to be shared with us, because I believe from the action, there was no board resolution that supported the project between Blue Ocean and Holland. And I rest my case. Thank you very much. Thanks for listening.
No, okay. Thanks very much, Blue Oceans. Then let's move to Holland Insurance. Holland Insurance, over to you.
Good morning, Mr. Chairman. My name is Vili Lategan. I'm the Group Chief Executive of Holland Insurance. With me today, I've got two colleagues, Mr. Danny Joffe, the Head of Legal, and Mohammed Patel, the Head of Compliance, who's also our primary point of interaction with the regulators. Honorable Chairman, members of the committee, members of the financial sector regulator and other attendees, thank you for the opportunity and the invitation to respond to the matters. We did not have the documentation beforehand and are not able to also prepare a presentation on this. But I would like to make a few comments on what was shared. I think the first is, as was already mentioned, that the case between Hollard and Blue Ocean is subject to legal procedures instituted in the Johannesburg High Court in August 2024. And I think that probably limits our ability to respond to all aspects of what was raised here. But I think it is important to make a few items of context in here. I think the first is that just about Hollard, and I wanted to just introduce Hollard to the organizer, to all the attendees here. So Hollard is an insurance group in South Africa. We operate in both life insurance, non-life insurance, and investment management. It's a purpose-led organization. The purpose is we enable more people to create and secure a better future. I think as an organization, we've got a very strong track record on, firstly, entrepreneurship and innovation, and businesses that we've supported in the South African insurance industry on that. Secondly, on transformation in various parts of the value chain in insurance, whether that be in distribution, whether that's in products and solutions that we offer, suppliers, and in terms of our employees. We are being regulated and we take that quite seriously. The standing that we have with the regulators and whether we comply with acts or regulations or certain conditions that's Hollard specific imposed by the respective regulators. But at the same time that we have a good working relationship with these regulators. I think ultimately for business to succeed, it's very important that it delivers good value to customers, the right solutions, and be transparent. And in terms of what we charge, what we do, both to the intermediary, the customer, and actually proud us on our conduct with them. When I get back, I think it's very important then just the context again of the legal procedure, so we'll be limited in our response. But I think the first is that the relationship between Hollard and Blue Ocean is governed, in my view, by four specific elements. The one is the Insurance Act and the other parts of legislation that's appropriate, the FICE Act. Second, a memorandum of understanding that was entered when this business opportunity was brought to us by Mr. Skosana, and the legal agreements that resides between Hollard and Blue Ocean, as well as then the exemption that the FSCA allowed for the period of 3 years. So then reverting to the facts of the matter, and thereafter I will ask Danny Joffe maybe to respond on more specific items, is that a big part of the memorandum of understanding was actually based on the business opportunity that was presented. Having required skills, access to markets, access to distribution, the right capabilities, and well as capacity. And I think within that specifically reinsurance capacity, because for all insurers, we need reinsurers to operate. I think then it did show that in the business case that it is not a viable business, and that's why we approached the FSCA, that on certain projections, certainly with the dispensation or the exemption, that becomes viable. But it became clear in the process that one, the business is unable to progress from an intermediary to a UMA and from there further on, basically because of a lack of those items, reinsurance capacity, the appropriate skills, the capability of the business. And business volumes, the nature and the quality of business clearly indicated that the business is non-viable. And those were really the drivers of Hollard getting to the decision to terminate the agreement with Blue Ocean in terms of the intermediate agreement that we had. I think we had some clear lessons to learn here. We cooperated with the FSCA on its review, and we concur with the conclusion of the FSCA as well as the recommendations that were made, and that's already been implemented. I think just in terms of the facts here, as I said, a lot of this should actually be subject to the legal process. But in my view, two very important comments. The first, just to Mr. McCarthy. Mr. McCarthy invested in Blue Oceans on the basis of the business case presented by Winston Konsana. We had many discussions about Hollard being able to support the business, but we never wanted to fund salaries of any business, but we supplied accommodation, support for technology, for payroll, many other aspects like that. And I think that's actually a significant error. I have not met Mr. McCarthy before it was clear that he was an investor in Blue Ocean. I think the second, for me, this is a matter of, kind of commercials, financial, business viability, and ability to succeed, and not an item around systemic transformation dispute that we have. So with that, Danny, I'm happy to hand over to you, maybe to comment on some other specific items.
Thank you, Veli. Thanks very much. Good morning, Chair. Good morning, members of the committee. Good morning to our colleagues in the FSCA and everybody else who's attending today. So, yeah, Veli would have, as Veli said, just maybe for the record, we obviously just want to say that Rule 89 deals with sub judice matters, and no member obviously can reflect upon the merits of any matter in which a judicial decision in a court of law is actually pending. So I don't want the fact that we're not going to respond to maybe each and every comment that Mr. Toscana or Mr. McCarthy has raised. It shouldn't be sort of construed as an admission or concession in any way. Obviously, this is not a court of law, and we can't test factual disputes here. There's no cross-examination, and I don't think that's the purpose of why we're here. So I just wanted to make that clear that there's a lot of facts that might have been stated that we don't agree with, but this is not really the forum for us to have that dispute. What I did want to say, one or two comments that Mr. Skosana raised that I do need to sort of respond on. The first is that the issue of TCF, because that's a generic issue and Hollard prides itself on being a TCF organization. One of the points that was in the exemption very specifically is that Blue Ocean may not deal directly with customers, that the customer had to be represented by an independent broker. Both we wanted that and the FSCA wanted that, because if the customer is represented by their own broker who's fighting their own fight, any potential TCF issue that goes around the pricing will very quickly be picked up by the broker. This wasn't personal lines insurance, it was corporate insurance, it's commercial insurance. So the customers are highly informed customers, they're proper corporates who are represented by CFOs who are buying the insurance policies, understand how the premiums work, and they're represented by strong commercial brokers as well. Certainly it's been our experience, if there's any issues with premium, those commercial brokers would have come forward. We didn't have one complaint from any of those commercial brokers who serviced any of the policies that eventually came to Hollard to be underwritten regarding the premium. So I wanted to make that clear that we don't believe that there was any risk from a TCF perspective. The other point was, as part of the deal, Blue Ocean was to prepare the quotes for Hollard to sign off. So the premiums that were prepared would be prepared in a schedule for Hollard to sign off. And if there was a debate as to how the financial model should work on each specific policy that wasn't being accepted for a specific reason by a broker, that clearly could have been discussed with Hollard and dealt with, which wasn't. Again, also, the 10.5% extra commission on the exemption was a maximum of 10.5%, so it didn't have to be paid on every policy. If Blue Ocean believed there was a specific policy that was going to be too expensive because of the 10.5%, then obviously the 10.5% didn't have to be charge on that specific policy. Again, that query was never raised with us on any specific policy. I just wanted to raise also that prior to when the MOU was agreed, Hollard, prior to applying for the exemption, investigated many avenues in which to assist Blue Ocean. There's an ESD agreement, an Enterprise Supply Development Agreement, in which Hollard gave funding in terms of a loan converted to a grant of R1 million. Blue Ocean used Hollard's offices. Yes, they did pay rent, but they had access to Hollard's offices. Hollard sat in many strategic meetings with them to get strategic input. Hollard provided its top underwriters in its corporate division and its Johannesburg commercial branch to assist. So we want to make it clear that it wasn't just the exemption. I think we're putting a lot of emphasis on the exemption that went on here, but there was a lot of other avenues that Hollard used and tried in order to make the specific thing work. When the exemption was applied for, originally the FSCA was reluctant to endorse the exemption, and there was a bit of a debate between Hollard and the FSCA as to where the exemption should sit. Should it be in an outsource agreement for outsource fees, or should it be for commission? We eventually settled on the commission, and originally the FSCA was reluctant, and I think their original decision was not to grant the exemption, which Hollard was going to accept, but obviously on heavy motivation from Blue Ocean, eventually the exemption was granted. So Hollard were prepared to facilitate and assist with that. But a lot of the pressure, once the original decision was made by the FSCA, I think came from Blue Ocean, and the motivation came from there. Again, lessons learned, as we've said, we agree fully with the FSCA that no rules were broken, no regulations were broken, and I think that factually will bear itself out in all the reports. So in our view, the real consequence is, Mr. Skosana raised the issue of many issues in the exemption having been breached, etc. The exemption is quite clear. If anything gets breached in the exemption, the consequence is that the exemption gets withdrawn. That's the consequence of it. So we don't believe there should be any further consequence. And any financial liability that comes from that will be tested in the court case. It's not, it shouldn't go any further. In terms of the FSCA's mandate, they just said they would withdraw the exemption. We actually approached the FSCA ourselves to withdraw the exemption. It didn't work the other way around. It was when we picked up that there was no viability with a particular scheme that the scheme then got cancelled. Again, the decision to cancel the scheme was purely based on the fact that only 8 policies actually incepted in the first year. Comprehensive due diligences were performed by Hollard's team to assist, to add value to them. But at the end of the day, we couldn't give an underwriting manager agreement because those due diligences weren't passed. And so Hollard, obviously, in terms of the regulation, we have a careful balance that we had to walk here between our strong value of financial inclusion, but also the prudential and solvency obligations which we owe our clients, we owe our board, we owe the Prudential Authority. Again, I stress this word personal lines policies. These were commercial and high corporate policies. Any underquoting for clients obviously can have a serious impact on solvency or claims that come later. I think that's all I want to say, given that the evidence, again, that Mr. McCarthy's asked for regarding board resolutions and all of that, they'll have full access to that in the court case. There's discovery that gets made of all the evidence that comes out. There's no hiding anything. There's full transparency. There always was full transparency. If one has a regard to the MOU, we were very clear that the full reinsurance had to be brought to Hollard by Blue Ocean. They agreed to do that. The reinsurance was never procured. And I'm not going to go any further than that, to say that evidence will obviously be brought in court and tested in court. Again, I thank the members for giving us the opportunity and availing us the chance to come and just give some of the facts that we were faced and the reasons why we made the decision. Thank you very much.
Thank you, Hollard. I want to indicate to members that we don't have Tebo unless he has joined. We received an apology from Mr. Isakov that is not going to join this meeting because he doesn't have data to join. I don't know whether that was the correct version of him not joining this meeting, because most of the time he calls me and we have got a long conversation. He send me WhatsApp, I respond. He calls Sister Tebu, she respond. But for some reasons, he says he doesn't have data to attend this meeting. And attending this meeting, I don't think it take 100 Rand worth of data, because the longest that we take is 3 hours. And I think with 200 Rand or so data bundle, you can attend this meeting. So I find his reasoning for not attending this meeting very strange. Because for almost the better part of last year and this year, I was having an engagement with him, and most of the time it will be him insisting that he wants this platform. We grant him the platform, then he gives Parliament the excuse that he doesn't have data. So I want members to know why Mr. Ryan Asakov is not here. That's the explanation that he has given to us after we have invited him to this platform. So he's not there to give his side of the story. Before I invite members of the committee to engage the presentations, I will request Advocate Jenkins, who's our legal advisor, to assist us as to how do we go through dealing with these issues. Advocate Jenkins, over to you, just to assist us with the procedure. Because as you have heard, there is a matter that is before the court. Of course, there is prejudice in that regard, and so on and so on. And also our sister committee dealing with the trade, industry and competition to a certain extent is involved in this case. So please assist us. Then I will open for members to ask clarity-seeking questions and make comments. Over to you, Advocate Jenkins.
Good morning, Honourable Chair. Good morning, Honourable Members, officials from the entities FSCA and the representatives from the insurance company Hollard and Blue Ocean, as well as the other colleagues of mine and other members of the public. Good morning. Thank you for the opportunity to assist the committee. Honourable Chairperson, as you indicated, my mandate as a legal advisor is to just guide the committee according to the Constitution, the Powers and Privileges Act, as well as the rules of the National Assembly that's applicable. And we have had some reference to that this morning. So, Chair, I think just to set that out, the committee is mandated to have oversight over the Financial Sector Conduct Authority. So that is the fundamental issue that the committee is tasked with today, and to see whether there's compliance with legislation as required in terms of the Constitution. So in other words, plain language, did the FFCA do their job as assigned by Parliament in legislation to the FFCA? So what we've heard this morning is basically a lot of issues coming up between the relationship, and I'm dealing with the Hollard Blue Ocean matter first. The relationship between Hollard Blue Ocean, the funding model, exemptions, and then those conditions, that's kind of critical, the conditions for that exemption that surrounds the funding model, as well as whether there was or was not a board resolution, and whether the board resolution in fact was required by those conditions. And Chair, just the last issue, and this is just what I've picked up, there might be many others, the treatment of customers, and that includes, that's a specific mandate of the FSCA. How did this success and non-success of this business relationship affect the customers, and what will FFCA do about that? And in this process, it's not for the committee to express itself on the litigation or any other matter, really, whether the relationship between Blue Ocean and Hollard was acceptable or not acceptable. Of course, members, and I might say this, members are free to speak. In terms of the Constitution and the Powers and Privileges Act, they have immunity from any criminal or civil liability, so they are free to speak. But the function of the committee and the purpose, the sort of end game of the committee is to see whether the FFCA conducted itself according to legislation. There was a reference to Rule 89. Of course, that rule only applies to members, not to officials like myself or any other visitor to the committee. So let me just put that out there. And that Rule 89 says that members may not reflect on the merits of a matter. Chairperson, I mean, we've heard some of the issues involved with this matter, so I think members can steer clear of that, but I don't think this is a risk in this discussion that the committee is having with the FFCA, really. And I think the court will also see it like that. Parliament is supposed to do robust oversight over its entities to ensure that there's good governance in the country. So I think the Rule 89 needs to be understood in that context. The issue of transformation is, of course, of critical public importance. And that's a line that is threaded throughout the Constitution. And I think that is not something that can be lost in the discussions of the committee. Be that as it may, of course, the issue of commercial transactions is a matter that's there, but that is more the issue between Hollard and Blue Ocean. And I'll leave it at that. Chair.
You are muted, Advocate. Advocate Jenkins, please unmute.
Sorry, where did that happen? I didn't see how that was up, and maybe that was inadvertently. I didn't try to mute myself. I was just getting to the other issue, Chairperson. The investment in Absa Bank that went over to FNB. Chair, on that matter, of course, we didn't hear what the complainant has to say, and we've got only the version of the FFCA on that matter. And again, all that the committee is required to do is really to inquire from the FFCA or to evaluate the FFCA's compliance with its legislation. Chair, to give effect to what the committee can do, of course, at the end of the meeting, if there are unresolved issues for the committee, the committee can ask the FFCA to report back on it. That's a specific power that it has in terms of the Constitution. So in engaging with the FFCA about these two matters, the committee can ask for a report following if there are specific questions or unresolved issues that the committee wants to see whether the FFCA conducted its mandate according to the legislation. Chair, again, my apologies for that muting. If there's any case, some that you need some clarity on, I'm here for the committee. Thank you very much, Chair.
Thanks, Advocate Jenkins, for that advice. Let me invite members of this committee to engage with the presentations. Honorable Alexander.
Thank you, Chair. And also just off the back of Advocate Jenkins, my question is to the FFCA. And the FFCA's letter suggested that Parliament shouldn't escalate the matter that has already been conducted through the regulatory process. Does the FSCA acknowledge Parliament's constitutional oversight authority, and where does it draw the line between regulatory independence and Parliament accountability? Thank you, Chair.
Thank you, Honorable Alexander. Honorable Van Rijn.
Thank you very much, Chairperson, and a very good morning to all in attendance. Chair, let me start with the matter on the Blue Ocean and Hollard. You know, Chair, we all agree that the constitutional provision of transforming the financial sector post-1994 has not been met. And as MK Party, we also conducted our own study, which is confirmed by various studies that were conducted by various research think tanks that we are not doing well in terms of transforming the financial sector. So I'm bringing this background, Chair, because it's very painful, I mean, to have to sit in a meeting and listen to how such a good initiative, an initiative with a clear intention of assisting to drive that agenda of transforming the financial sector failed. It's very, very painful. I so wish that the matter could have been handled differently to make sure that this other entity, Blue Ocean, is empowered and is able also to be counted as one of the success stories in as far as transforming the financial sector agenda is concerned. But unfortunately, it's all clear listening to the two sides of the story that this seems to be something that has dismally failed. It pains us as MK Party to be listening to such stories. But well, Chair, I think you have covered my other observation, because if the matter is the subsidiary care rule enjoins us as members of Parliament to be very, very cautious when we deal with matters that are in front of the court of law, and I think the Advocate Jenkins also confirmed that. My question will be mainly on what I think might be the mandate of this committee, or my mandate as a public representative. You know, I'm equally perturbed by the statement that Blue Ocean pressurize FSCA. I think this is a very loaded assertion, and you know, it's something that we shouldn't treat light, given our mandate as a committee. And I think it will be important that we get details of this pressurization, because it leaves more questions than answers, because pressurization usually takes different forms, and the list is very long. It can range from political pressurization, it can range from intimidation, it can range from threats, so it will be important that this thing is clarified, because we can't just leave it without getting clear details of what constitutes this pressurization. And I would like to hear the response of FSCA on the response turnaround time, because if it's true that it took 13 months for them to respond, and given the caseload that they've presented to us, I'm of the opinion that there is an area that we need to look at from an oversight point of view and performance of an important institution of their caliber. But also what came out from Blue Ocean is that it all happened after the matter was elevated with maybe with the executive authority or with National Treasury. So the question is, how many cases are not attended because they are not elevated the way Blue Ocean has elevated the matter? So from a performance point of view, I think it will be important for the FSCA just to give an indication of what the turnaround time, or maybe what might be the issue here. Maybe there's something that we need to hear of in terms of their capacity, but also in terms of the issue of their performance. And obviously, since we are concerned about transforming the sector, I think there are lessons that we need to learn from this transaction. One of the areas that Holland, in fact, FSC indicated is that the capacity of Blue Ocean, in fact, they oversold themselves, you know. So I'm not sure which boxes of compliance did they not tick. So as out of this, we are able, as we advise as public representative, other entities to tick those boxes. I think if that information can be shared, because we also hear Blue Ocean contesting that, you know. So I think it will be important to hear which boxes didn't they tick for them, because I think the initiative and also the exemption that they were accorded, it was a very interesting model. So obviously, FSCA also confirmed that they still need to look into other areas of institutions who can comply for us. But I think it's a very good model where you are bringing in small entities like Blue Ocean to grow under the wing of established entities like Holland. So it's important for us to understand the details of that model. Hence, my question, Chair, is what might be the areas that made FSCA, I hope this is not encroaching to the litigation process, to regard as areas of capacity problems on the side of Blue Ocean. Well, the issue of the one of Mr. Isakov, I don't think one should dwell into that because he's also not present. But my question is the transition from Sambo to FNB. I'm not sure if FFCA have received any complaint around that transition, not necessarily this one, because we might be talking of only this matter, unaware that there are other complaints that were lodged as a result of that transition. I'm not sure if there are any complaints that have been registered with FSCA around this particular transition. Thank you very much, Chairperson.
Thank you, Honorable Fandre. Honorable Squat.
Thank you, and let me as well welcome the report that we actually received from the FSCA, but as well thank the stakeholders who have been able to come in and be able to set the side of the matter so that we are able to understand what exactly is taking place. However, Chair, in terms of the Blue Ocean matter, I'm of the view that it's just going to be a bit difficult for us to get into the matter, except to deal with the issue of the role that is played by the FSCA because of the level where the matter has been taken to. So it has actually overtaken us. It would have been much better to deal with it when it was still fresh. However, Chair, I wanted to understand, because this indeed is was a step forward in the right direction in terms of dealing with the issues of transformation within the financial sector. Now, one of the issues that I want to understand, Chair, is in terms of the development of a transformation framework, which would enable the incubation of SMMEs, which would actually constitute an important aspect to drive the financial sector transformation charter. Now, I want to understand what the incubation model and regulatory framework is required for major financial sector players to partner with SMMEs in the financial sector. Do we have such a model? Because here, Chair, one of the things that one realizes is that from time to time when we deal with issues of transformation within the sector, it's more about exemptions, and it actually from various exemptions given, it really shows like these exemptions are not working, and therefore we need a proper model that we should be able to follow without necessarily giving exemptions, because exemptions, yes, we can give as we support, so that we are able to allow or make it possible for the SMMEs to be able to grow. But if transformation model is going to be, based on exemptions, I don't see us moving forward, particularly in terms of transforming this financial sector. So I just want to understand, is that a model for incubation? The second one, Chair, it's the turnaround time. I want to agree that perhaps FSCA need to give us the standard in terms of turnaround time so that we're able to understand whether this response time of 13 months was within their standard, or whether they had difficulties, or whether it's something that they are dealing with. But what would be the normal turnaround time in terms of the cases that they're dealing with, so that they are able to respond to whatever concerns that are there? Yeah, let me leave it there, Chair. And I agree that the other matter, we should not, the Isakov matter, it will be difficult when the complainant is not even in the meeting. Thanks, Chair.
Thanks, Honorable Squati. Let's invite the FSCA to
Chair.
respond.
Chair.
Mauta.
Yeah, maybe before you go. I did, but my hand, you hardly see it, Chair.
I know the blue, that dark brown.
Yes, Chair, if I may, before FSCA comes in.
Okay, no problem.
All right. No, thank you, Chair, and greetings to the colleagues, greetings to the stakeholders that have joined today. Chair, let me join my colleagues in also echoing the same sentiments that we might not be able to dwell with the merit of the issues now. You're fortunate yourself because maybe you've been fortunate enough to be seized with this matter for some time. We just came to learn about it. So we don't have much information that we would need, but also saying that there's a sub judice issue there, it might be very difficult for us. So maybe if we can just agree that we will, after this meeting, Chair, we will set up some time so that we can deliberate on our own and see what can be done. Chair, it starts with a political will. I agree with my colleagues that says that there must be a political will to transform the financial sector. And that role should be played centrally by the FSC. They must appreciate that at least there is that effort in this country for us to transform the financial sector. And when small players like Blue Ocean comes on board, we should appreciate them for who they are, more so that they come into an industry which is very technical and very administrative. So the role of FSCA is not to just whip, but to guide through the process so that we see these small companies growing within this sector. It must be a deliberate effort by these institutions to assist in pushing the same thing that we are pushing here. I think it's been that we need to transform the financial sector. There's no debate about it. But if our own institutions are not playing a role in assisting government to achieve what it wants to achieve, then it defeats the whole purpose. And it's like Honorable Scott was saying, the process has gone left. So we're standing here now right at the tail end of this problem. Whereas if we had gotten sight of it in the early days, we would have probably intervened as committee through our oversight mechanism and tried to save the situation. So, but I think let's not dismiss it, Chair. Let's just agree that we will have a deeper insight into what happened and how then do we assist the small companies. In the matter of Mr. Isakov, it's unfortunate that he's not here to speak for himself and to explain to us what happened, for us to be at least be able to understand what is the issues. But knowing the financial sector, how they are, the banks and all, you can already tell that there's a problem there. There's a bit of pressure that was put. You can just assume that the powerful once again are using their power to suffocate our people, and it can be correct. But we will not comment much because we don't have the complainant here now. But it's a cry of a fellow South African who says the powerful are yet again doing what they do best, which is to pressurize and get away with murder. But I think it's a matter, once again, that we need to look into and try to intervene. Today is Mr. Isakov, tomorrow is one of us. And it will not be nice for us to just sit back and say we can't do anything. That will be all from my side, Chair. But centrally, there should be a political will. The message must be clear that there must be a political will to transform the financial sector. And all institutions that are supposed to be supporting this initiative by government, by South Africans, should do their part also in trying to do what the government is doing. Thank you, Chair.
Thank you, Honorable Moto. Let's invite FSCA to respond to issues that have been raised by honorable members. Over to you, FSCA.
Thank you very much, Honorable Chair, and thank you also for all of those questions. I hope I've gotten them all down. I'm going to try my best to respond to as many as possible. I think there may be one or two that we may need to come back with information. I will go through them one by one, and when I'm done, if any of my colleagues want to weigh in, I think that would also be good. So I will start with the question from the Honourable Member Alexander around, does the FSCA recognise Parliament's oversight role of the FSCA? And if so, how do we distinguish between the oversight and regulatory matters? So I think, firstly, it's very important to emphasize that the FSCA does very strongly appreciate, respect, and accept the oversight role of Parliament. And I'm hoping we have also demonstrated this in our engagements with Parliament and with this committee, particularly over the last few years in terms of the sharing of information. We agree that as elected representatives, you have an incredibly important role, particularly since the core mandate of the FSCA is to actually serve the public in terms of financial customers. I think, Honourable Member Alexandra, the point that the Commissioner was making in the letter around the concerns of having to relitigate matters before Parliament was less about not appreciating the role of Parliament and more about recognizing that there are existing structures and mechanisms for decisions of the FSCA to go through first, whether it's through the tribunal, whether it's through the courts, etc. And we also need to make sure that those institutions and those processes are respected and fully ventilated. I mean, of course, if this committee has a view that things should be and could be done differently, we are, of course, very happy to engage. I think our concern is because of...
Sure.
Sorry? Honourable Chair, I don't know if somebody is not muted and is speaking, or if I can continue.
Please continue. Members and stakeholders, please remain muted. Can you attend to the person who's unmuted? Thanks.
I think the other challenge is, and you would have seen through some of these issues, they are extremely detailed and complex and do require a lot of, I mean, we appreciate that every party has a side to the story, but they are incredibly complex testing of evidence and issues of that nature that need to be interrogated, which we do believe are suited for institutions like the tribunal and the courts. I think the other concern is, again, when it comes to the pure regulatory decision making, I mean, as has been mentioned earlier, due to the volumes of matters that we need to deal with, one of the risks that we need to manage is that there is finality and there is certainty to the decisions that we make. So I think it's less about questioning whether the committee has a role to play in interrogating our processes and decisions, but actually having a discussion around, but where does it end, especially for complainants who are dissatisfied because decisions don't go their way, and perhaps that is a discussion that we should have further. I would also welcome, once I'm done, just our general counsel to step in and just to clarify again our understanding on the line, the independent line between the role of the regulator within the context of both the oversight role of Parliament as well as the role of Treasury and in particular the Minister of Finance. Moving on to the next set of questions by Honourable Member van Rooyen. And again, I have to say at the outset, I share your disappointment and I share your regret that this type of arrangement did not work out. I mean, as I've said earlier, we, similar to also as the last member raised, are concerned about the state of transformation and the lack of meaningful progress. And for us, this was an opportunity to try and find a more innovative way to bring in smaller businesses that maybe had not had opportunities in the past. I also hear your concerns around the statements that have been made around the pressurization of the FSCA to release the report. And at this point, I do need to clarify and confirm some comments that were made. In our presentation, what we said was that the FSCA had been pressurized to conclude and release a report. We at no point had said that we were pressurized to release a report that was favorable. I think where the implication for that comes in, and you would have heard Mr. Skosana himself had said that they were concerned about the timelines and they did want the report to be released timelessly, because in his own words, the delay of the report was impacting their ability to proceed with the litigation that they'd instituted against Hollard. So implied in that, there was reliance to be placed on the report, on the outcomes of the report, irrespective of whether it was favorable or not. So I do think it's quite important to clarify, we at no stage are accusing or have accused Blue Ocean of pressurizing us to release a report that was positive or favorable. What we are saying is that we were pressurized, again, and I hear the comments about the time, to release it a lot sooner, because in their minds it would have an impact on their ability to proceed with the action against Hollard. I will come to, actually no, maybe I should get to this, because there were questions by several members around the turnaround times. I think Member van Rooyen, Sekwati, and Member Ompi all raised the issue around timelines. So yes, this matter did take almost 13 months to finalize. Again, to clarify, it did not take the FSCA 13 months to respond. The FSCA does have a set of indicative service level commitments and timelines within which cases are assessed. And I'm careful about not using the word investigation, because this was not an investigation. This was a supervisory matter, and perhaps we could have a separate discussion around the difference between supervisory engagements versus matters that are handed over to our enforcement team for investigation where there are actual material breaches of law. This was a situation where we had to do an assessment of volumes of information that were provided to us both by Blue Ocean as well as Hollard. We note the comments that Mr. Skosana has made about they submitted to us lots of evidence and lots of communication, which we assessed in detail. Similarly, we received reams and volumes of information, very technical and complex information. As you would have heard, there were lots of technicalities around the structure of the arrangement, the structure of remuneration, and we needed to go through a lot of details to actually extract the parts of the information that were relevant to the regulatory considerations versus those that were relevant to the commercial dispute. So that was one of the reasons why there was, it did take the team a lot of time. There was a lot of time spent interrogating and verifying the veracity of information that was provided to us by both parties, because we did need to be balanced in our approach. The second point to raise is, as I've said, it did not take the FSCA 13 months to respond to the matter. It took 13 months for the matter to be concluded. During this 13-month period, there was significant back and forth between the FSCA teams, between Blue Ocean and with Hollard. So there was responsiveness, but again, in light of the complexities, there was a lot of information that was being given back and forth. We also did several follow-ups in terms of further interrogating information that was provided to us, and that was another contributor to why it took so long to conclude the matter. The final issue, or one more issue that I wanted to raise, in terms of, because this matter dealt with a regulatory exemption, we do have a requirement in law that when it comes to exemptions that are provided to institutions like Hollard that are overseen both by the FSCA and the Prudential Authority, we cannot make a final decision whether it's to grant the exemption or to withdraw the exemption without actually gaining the concurrence of the Prudential Authority. So within this process, before we could also issue the final report, we did need to engage with and provide a lot of information to the Prudential Authority for them to provide a view on whether they concurred or agreed with our reasoning to withdraw the exemption. So these are kind of multiple touch points within the 13-month period that unfortunately resulted in the delay. In terms of the question around, do we actually have specific timelines and turnaround times? Yes, we do. And there are different timelines depending on the nature and the complexity of the matters that we deal with. I obviously don't have that data offhand, but if the committee would like to see a list of turnaround times and SLCs across the FSCA, we're very happy to share it. Also to note that this is something that we are continually reviewing to make sure that our response rates remain efficient and effective. But like I said, we would be happy to share detail on that if it's required. I think the other issue, and I understand that it may seem extremely coincidental that the finalization of the report by the FSCA did coincide with the matter being elevated to the National Treasury, but I will categorically say to you that they were not connected. It really was coincidental. I mean, of course, there was no reasonable way that we could have been able to come up with a report in such a short period of time, just because this was escalated to Treasury, and this is borne out obviously by the details and the technical nature of that final report. I think we're also happy if we need to share information, if necessary, around the internal governance and protocols that we had to go through before we could actually finalize that report. Again, it is unfortunate and coincidental that the timing of that report coincided with the matter being escalated to Treasury. I think in terms of the questions around the details of Blue Ocean overselling its capacity. So just to clarify, this was not overselling itself in terms of regulatory compliance. I think what we're trying to say is from both Blue Ocean and Hollard's side, they both overestimated the amount of effort and capacity that would be required in order to fulfill their sides of the agreement. And actually, I think the correct party to respond to the extent to which Blue Ocean was unable to fulfill its side of the transaction or of the relationship would fall on Hollard. But again, this is part of the commercial and contractual dispute that is before the court of law. So unfortunately, we won't be able to provide a lot more detail on that. Then just moving tack on the question around whether we've received other complaints on the transfer from Sambo to FNB. Honestly, this is another question where we would need to go back and come back to you. I cannot offhand say to you if we've received complaints, the number of complaints, and how we've dealt with complaints relating to Sambo. I mean, of course, if Fani is on the line, if he is aware, I'm also very happy to defer to him if he is aware in the history of both the FSCA and FSB, if we are at this point aware of other complaints that we received and how we dealt with them. The questions from the member Sekwati, and I think it's a very good and important question around whether the current framework actually allows for incubation for these models where there's support between kind of more established players and smaller entrants. And this is something that I think is desperately needed in our framework. Unfortunately, it's not something that is currently allowed for. The current framework, the current financial sector framework generally does not have any sort of requirements or principles around this. The only provision relating to transformation in the insurance legislation is actually in the Insurance Act, and it relates to the Prudential Authority, and it talks around considerations that the Prudential Authority needs to take into account during the licensing of insurers to understand their plans to actually meet transformation targets. Aside from that, there are no provisions, there's no facilitation through the framework around facilitating these type of incubation partnerships. And I completely agree, this is something that could be an excellent model to help accelerate transformation in a more meaningful way. What I will say, and I think this also goes to the question that was, and I'll probably end here, the question that was raised by the last member around the political will and the importance of the role that the FSCA needs to play in terms of enabling, facilitating, driving, and guiding these types of transactions. Once again, we agree with that, and we are fully committed to play the role. Like I said, again, unfortunately, we don't have those powers. We don't have a framework that enables us to do that. However, this is something that has been recognized both at a policy level through the National Treasury as well as us as the FSCA, which is why there have been deliberate inclusions in the conduct of financial institutions that will give the FSCA the power to provide stronger oversight, to develop standards, to provide guidance, etc., in terms of these types of arrangements. And I think to the point of the political will, I think it's very important for this also to be considered when the COFI bill comes before this committee, because once we have finalization on that, a lot of the questions that the members have asked around the ability, the capability, and the powers of the FSCA should be resolved. I'm going to stop there. I think I've covered everything. I'm not sure if Fani or Mohompi, there's anything else you wish to add, or if there's anything that I've left out. Again, just to reiterate and conclude, if on any of these items you do require additional detailed information that I don't have offhand, we'd be very willing to take questions offline, which we can respond to in writing if required. Thank you very much. I'm not sure whose hand is raised. Okay, it is Fani. So over to you, Mr. Chair. If not sure if you would want to go to our General Counsel for any of his remarks.
Yeah, he's welcome to make an input or respond to issues raised by members.
Thank you, Honourable Chair and committee members. Just on the question from the Honourable Member van Rooyen as to other complaints about the transfer of the banking business from Sambo to FNB. Well, let me first of all say, I don't have any personal knowledge of complaints that were lodged with the then FSB or recently with the FSCA about that. It's something that we will have to check to give an accurate answer there. What I can perhaps indicate is that the curatorship of Sambo, I think, took place from February 2002. It was overseen by the Registrar of Banks within the South African Reserve Bank at the time, and the FSB was not a regulator that was involved because the oversight over banks didn't resort with the FSB at the time, therefore I do not think that there would have been complaints about that transfer eventually from the curatorship to FNB that would have come to the FSB at the time because it wasn't a regulator. I am aware of various litigation around the matter of the transfer, including the calculation of interest, also something that I think have played itself out in the courts, and that it would also have been resort at the time under the Registrar of Banks and not with the FSB within its mandate. Thank you, Chair.
Thank you. I think we should round up the meeting after the responses from FSCA. And just to indicate that moving forward from here, we'll engage the committee, Portfolio Committee on Trade, Industry and Competition, as this matter is transversal. It cuts across two or more committees. And then members will remember that we also have an outstanding meeting with that Portfolio Committee chaired by Honorable Masina to finalize the report on the transformation of the financial sector. You will remember that last year we had a joint meeting of the two committees in the Good Hope Chamber, where we met stakeholders from the financial sector to deal with this matter of financial sector transformation. So we have to compile a joint report to the National Assembly. That report will be the build-up to the report that has been there before. It will not be there for the first time for Parliament to be finished with a report on financial sector. There was a report that was adopted, I think, in the 5th Parliament, if I'm not mistaken. So we'll meet with our colleagues from Trade, Industry and Competition Portfolio Committee to deal with issues of financial sector transformation. Also, I want to indicate that what should be clear is that South African democracy is participatory and representative in nature. Representative in the sense that it is the citizens of this country that elect public representatives to represent them in Parliament. So we are not here on our behalf. We are here to represent 60 million plus South Africans and those that have elected us. So those that have elected us have got the direct access to this parliament to raise any issue of their interest. And what is important is for us as parliamentarians to invite those institutions of government whereby members of the public have issues with, to clarify those issues that they are worried about. So it was against this background that we invited FSCA. We know FSCA is independent in terms of taking certain decisions, but FSCA is accountable to the Standing Committee on Finance. So if members of the public raise issues about the FSCA, it is the responsibility of this committee for FSCA to come, like we have done today, to speak for itself and account for what it has done. As I've said earlier on, that Parliament has adopted a model that is called, if I can show you, you see this is what we call parliamentary oversight and accountable model that has been adopted. So we do things according to the book, that this committee play oversight, organs of state account to Parliament. So that's what we will continue to do, like we have done with the PIC, we have done with the Prudential Authority, and we will continue to do that to make sure that citizens are happy in the manner that we tackle issues that they raise with us. So thanks very much, honorable members, and also FSCA, Treasury, SCOF support team, stakeholders that are here raising issues, Hollard, Blue Oceans, and unfortunately, Mr. Isakov could not come. We'll see how we handle this issue moving forward, the media and everybody. Thanks very much. We'll continue to deal with this issue and in a manner that will not, as Jenkins has alluded, that we must be careful of Rule 89 as to how do you handle matters that are sub judice. So we'll treat on this matter very carefully, being guided by the legal team of Parliament. Sister Tebu, this is the last meeting before we go to Easter, isn't it?
No, sir, there's a meeting next week about we must adopt the report for our oversight to the borders and to the Financial Sector Conduct Authority and the Reserve Bank last year. So that meeting must take place on Tuesday.
Okay, no problem. So if that's the case, let's adjourn this meeting. We'll meet again next week, Tuesday. Thanks very much, colleagues.
Thank you, Chair. Thank you, Chair.
Thank you, Chair.
Thank you, Chair.
Thank you very much, Chair and honorable members.